80 words per minute for 10 minutes. 5 seconds more. Start. This appeal has been filed by the landlord against the judgment and order of the High Court of Delhi. The High Court held that the respondent tenant had not sublet the premises to his son-in-law in pursuance of a partnership deed entered into between them. In the meanwhile, respondent tenant died and was substituted by respondent numbers 1 to 5, that is, his widow and 4 daughters. The respondent number 1 was deleted from the array of parties upon her death. The landlord sought the eviction of the tenant on the ground that the tenant had sublet the premises to his son-in-law in contravention of Section 14 of the Delhi Rent Control Act 1958. The landlord had also sought eviction of the tenant on the ground of arrears of rent. The tenancy was in respect of a kirana shop at the monthly rent of rupees 50. The tenant was an old and infirm man, incapable of running the business on his own. It has been found that the son-in-law sat in the shop and conducted business exclusively therefrom. The dispute was whether he was doing business exclusively behind the facade of a partnership or as a genuine partner. It is an uncontroverted fact before us that the landlord's permission in writing was not obtained before the tenant had allowed the alleged subtenant to occupy the shop. The rent controller found that the partnership was a ruse and that it was the son-in-law who was in exclusive possession of the shop and running the business on his own. No books of accounts were maintained, no profit and loss accounts were maintained, and no stock registers concerning the goods in the shop were maintained as required by the partnership deed. Thus, the rent controller clearly found that the son-in-law had been put in possession of the shop in pursuance of a sham partnership deed and was not merely assisting in the shop as a son-in-law. With regard to the arrears of rent, it was an undisputed position that the tenant had been granted the benefit of Section 14(2) of the Act, as it was a case of first default and the tenant had complied with the order passed under Section 15(1) of the Act. The landlord contested the appeal on the only remaining ground of subtenancy. The High Court concurred with the finding of the appellate authority that the son-in-law had come to Delhi to assist his father-in-law in business for which a partnership deed had been executed between them, and he resided at the same premises as his father-in-law. The partnership was a genuine partnership, as it could not be said that it had been entered into for the purpose of subletting. Thus, the mere occupation of his son-in-law was not sufficient to establish a case of subletting. Having heard the learned counsels for both parties, we find that no consent in writing was obtained from the landlord before the so-called partnership was entered into between the tenant and the subtenant, and before the subtenant was allowed to occupy the premises. What is of importance is whether a person has been inducted genuinely as a partner and therefore allowed to occupy the premises, or whether the partnership is a ruse. The requirement of consent in writing, as in subsection 1, is retained. In the present case, there is no evidence that the tenant obtained the consent in writing from the landlord before allowing the son-in-law to occupy the premises in pursuance of the partnership deed. The arrangement between respondent tenant and his son-in-law was not a casual arrangement wherein the latter was requested to conduct business at the shop because the former was old and infirm. There was no need of entering into a partnership agreement in that case. We find upon scrutiny of the evidence in this case that the learned rent controller was right in coming to the conclusion that the parties had not acted on the partnership which was shown, and that there was a parting of possession of the premises in which the son-in-law was allowed to occupy the premises and carry out business exclusively. There is no evidence on record that the account books were maintained and the profits were shared between the parties as partners. In any case, there was a failure to obtain consent in writing from the appellants, which is a clear prerequisite for allowing any person to occupy the premises. In these circumstances, we find that the occupation of the shop by son-in-law amounts to a subletting and the respondents are liable for eviction. We accordingly set aside the order of the High Court and direct that the respondents shall be evicted. The appeal is disposed of with above observations and directions.